Now, arguments over whether Deputy Chief Justice Raymond Zondo could be biased against former President Jacob Zuma was the focus of the state capture inquiry yesterday. Zondo will today announce his decision on Zuma's recusal application in what is a test for reasonable apprehension of bias doctrine. Now, that argument has been refuted by the Commission. The one issue both agreed on, though, was that the inquiry will collapse if Zondo does recuse himself. Take a listen.
I'm surprised that a commission of this nature in this country, probably the biggest after the TRC, only has one person. That on its own was a political blunder, dare I say, but this was made by judges. I think to have one person in a matter that is so vulnerable to contradictions like the one that has arisen shouldn't have been done. As I said earlier, the solution to something like that is that it would really relate to the evidence that relates to Mr. Zuma. I don't know what you would do.
Is that it may be that a recusal would collapse the commission.
All right, let's unpack this issue for you now, particularly the issue of reasonable apprehension of bias. We're joined now by legal experts, Advocate Mkhululi Stubbs. Advocate, good morning. Thanks very much for your time this morning. It's a very interesting thing that Justice Zondo himself has to now go and consider whether he himself has this reasonable apprehension of bias. Just take us through how he would go about making that decision.
Yeah, so it does seem rather strange, I accept, that in circumstances where you're trying to find out whether someone appears biased, you're asking that person to make that decision. But the truth of the matter is that in litigation, in all litigious proceedings, that's basically the norm. The reason for that is really a matter of forensic prudence, I would say. And what I mean by that is a court will ultimately, if President Zuma decides to challenge whatever decision Deputy Chief Justice Zondo makes, will have to go before a court and say he got his decision on the reasonable test wrong. A court will then need to look at all the documents that informed his decision, and it will then only be able to decide whether it agrees with Deputy Chief Justice Zondo's decision or whether it thinks that that decision is so badly tainted that it means that the whole proceedings go by the board, which is a potential consequence. So, yeah, it is.
Yeah, I want to get to that in just a second, but let's just take a step back. And for those of us who, of course, are not in the legal fraternity, explain to us this issue of reasonable apprehension of bias.
Sure. So, reasonable apprehension of bias is something that's different to bias as the rest of us know it in a. And that just means that there's a specific legal test. The reasonable apprehension of bias will only be established where it is clear on the basis of evidence that there is an objective likelihood. So not a test about what do I feel, what are my feelings about the judge being against me or for me, but what can I substantiate from an objective and documentary perspective? That's the one point as regards the concept of reasonable apprehension of bias, but the important practical point is that the test is actually a very difficult, and that's because, at least partly, because there are two inbuilt elements in the test. The first test is that the position, when any court decides whether a judge did the right thing about recusing or not, is that the judge is assumed to be impartial. And the second part of we often miss the difference between neutrality and impartiality. Judges are not required to be neutral. They're still human beings, so they may lean one way or another. Those are the vagaries of being a human being, right? But it's a different question when it comes to impartiality. Impartiality is about overcoming one's natural biases, one's natural neutralness, if I can say it that way. Impartiality is something different to neutrality. So if you're going to get that test and you're going to meet the bar, you're going to need to firstly meet a high bar on the evidence, and secondly, you're going to need to show more than just neutrality or an absence thereof.
Yeah. I'm reading quite an interesting definition here on this issue of reasonable apprehension of bias. So it's, if I, as an informed person who's been tracking the proceedings at the state capture inquiry, if I think once a decision is made that, in my view, the Chief Justice may be biased in one way or another. So the Justice, what I'm trying to say is that Deputy Chief Justice Raymond Zondo also has to now think about the facts as they've been presented and whether there might be a perception that there is some bias.
Yeah, so that's absolutely right. The only addendum I would add to it is the reasonable perception. And I know it's just one word in a sentence, but when it comes to law, reasonableness imputes an objective standard as opposed to, as you mentioned, Melissa, you being a layperson who's going to the commission. And therein lies what the law decides is the distinction between feelings and evidence. The test is right, but there needs to be an objective basis for it. You can't simply scream, I feel as though there's reasonable bias. You need to do a heck of a lot more if you're going to clear the bar.
The other issue around, if the decision is that Justice Raymond Zondo does recuse himself from the state capture inquiry. We've heard from over 33 witnesses, and it's been really intensive witness testimony. There's been a lot of forensic evidence that's been presented and painstakingly gone through by the evidence leaders from the state capture inquiry. What would that kind of a handover look like to the person who would then take the Deputy Chief Justice's place?
So, in short, very messy, right? And the reasons you've already touched on. You have a judicial officer, namely DCJ Zondo, who has heard all of this evidence and needs to make his own independent judgment of the evidence that he's heard. A different judge would need to take in that evidence, would need to take it in a way that's fair to everyone concerned. So, for example, the judge simply reading a transcript and then making findings against, say, for example, President Zuma, could be met by a challenge from President Zuma's lawyers saying, he didn't ask me or she didn't ask me before making this decision. He or she simply looked at the record and decided without asking for representations. And that goes to procedural fairness, which does have the potential to vitiate the entire proceedings. The whole proceedings could go by the board. So it is something that a judicial officer will always be assiduous to avoid. Yeah.
And I think both sides of that argument yesterday at the state capture inquiry agreeing that if that recusal takes place, essentially, just from what you've said, the state capture inquiry would all but collapse.
Yeah, miracles do happen, but the stakes really are as stark as that. And if I may, what I would want to add to that is that this, from President Zuma's perspective, is an interesting legal strategy, right? So there's a saying that litigation is a basic legal right guaranteeing every corporation its decade in court. Now, I was involved in a case in 2008 indirectly that had to do with President Zuma's search warrants, right? President Zuma challenging Justice Zondo's partiality means that he will have another foothold after this commission is done to potentially go to court and say, you know what, DCJ Zondo messed up the recusal decision. And for that reason, you have to get rid of all of the commission's findings yet again. And it's not just that he'll make that allegation, it's that that allegation can go all the way up to the Constitutional Court and literally take years to resolve. So it is an interesting Stalingrad-like legal strategy. If you remember, Advocate Kemp J. Kemp used to be his counsel. That was a quote that was bandied about in the media at the time. So this is an interesting strategic point because it's a potential foothold for further reviews in the future.
Incredible stuff. Thanks very much for coming on to the AM report and giving us a sense of just the wide-ranging effect of exactly what today's decision would mean for not only the state capture inquiry, but for the legal fraternity, I suppose, and the other issues that are in court concerning the former president. That's Advocate Mkhululi Stubbs.